Second marriages can double your happiness and double your estate planning risk. One wrong clause and the people you love most could be hiring lawyers before you're even buried. That's because blended families face estate planning challenges most people completely overlook. The law doesn't reflect your emotional reality. You want to care for your spouse, protect your children, and maybe even leave something to a stepchild you love. But without a plan, your wishes won't be honored, and the people you care about could be left out or in conflict. Today, I'll walk you through the overlooked documents, traps, and trust tweaks that keep blended families out of court, so your spouse, your children, and even stepchildren stay protected and on speaking terms. Quick heads up, I'm a fiduciary financial advisor, not an attorney. This video is for education only. Use it to have a smarter conversation with your estate planning lawyer. When you skip planning, the state's intestacy formula decides who gets what. And the law only cares about bloodlines, not the family you've actually built. Imagine you and your second spouse have built a life together for over a decade. You've helped raise their children as your own, supported them through school, and created a blended family rooted in love and trust. But then the unthinkable happens. You pass away without a will. Under state law, your assets get divided between your spouse and your biological children. The stepchild you thought of as your own, they are left out entirely. If you haven't legally adopted a stepchild or put clear instructions in writing, the law simply won't recognize your intent. Most estate plans fail before anyone dies, during a stroke, accident, or dementia diagnosis. People think estate planning is about death, but it actually starts with incapacity planning. Let's say something happens to you, like a heart attack, and you end up unconscious in the ICU. Machines are beeping. Your adult son disagrees with your spouse about your treatment plan. Without legal documents, they end up in court fighting for control while you are lying there. In a blended family, this matters even more. Naming your new spouse as your agent might create tension with kids from a prior marriage. On the flip side, naming one of your kids as your financial agent could alienate your current spouse, especially if there is a history of mistrust or money disagreements. So what documents prevent this nightmare? In blended families, the wrong agent choices can pit spouse against stepchild. That's why we recommend thinking in two key categories. Number one, medical decision makers. Who speaks to doctors if you can't? Healthcare power of attorney picks your medical quarterback. They should know your values and be able to speak for you during emotional situations. Think of it like your backup generator. Without it, the hospital runs on candlelight. Slow, dim, and public. Living will outlines your end-of-life care preferences. This document speaks when you can't. HIPAA authorization lets your agent access medical records. Without it, hospital can't even tell them you are admitted. Number two, financial decision makers. Who keeps bills paid and gifts flowing? General durable power of attorney. Manages finances and if you specify it, keeps annual gifting to family or charity rolling. You must specifically authorize lifetime gifting if you want that to continue. Digital asset authorization unlocks online banking, crypto wallets, and cloud files legally. Just because someone has your passwords doesn't mean they have legal authority to access your accounts. Here's something most people get wrong, especially in blended families. They assign decision makers roles based on relationships, not readiness. Just because someone is your spouse or your oldest child doesn't mean they are the right person to manage your finances or speak to doctors on your behalf. Instead, match roles to strength. Maybe your spouse makes the healthcare decisions because they will be at your side, but your daughter manages finances because she's calm, organized, and experienced. That kind of intentional playing can reduce resentment and keep your family from splintering. And always name backups. Life changes, and so should your plan. For substantial assets, also consider naming a corporate fiduciary to manage financial decisions. They have no emotional stake in family dynamics and will follow your instructions without favoring anyone. It's an option many families overlook, but it can offer peace of mind when neutrality matters most. So once you've protected your decision makers and documents, the next step is make sure your actual assets are passed on clearly, privately, and according to your values, not just the court's default. That's where trusts come in. Many people assume a will is enough to protect a blended family, but that's often where things fall apart. Wills are public. They only take effect after death, and they offer very little control, especially in complex family dynamics. Trusts help you stay in control, caring for your spouse while protecting your kid's future. But here's the common dilemma. You want to make sure your spouse can live comfortably for the rest of their life, but you also want your kids to ultimately receive the inheritance. The problem is simple. Leave everything outright to your spouse, and they can rewrite their own will tomorrow. One option we often walk through with clients before they finalize anything with their estate attorney is a qualified terminable interest property trust. It can provide income to a surviving spouse for life, while preserving the principal for your children after they pass. Think of a QT trust like a house with two keys. Your spouse gets one key. They can live there, use it, but can't sell it out from under your kids. Your children get the second key. They inherit it intact after your spouse passes. No accidental disinheritance. No court fights. In some cases, separate shared trusts may also make sense, allowing each branch of the family to inherit on its own timetable and avoid unnecessary tension or confusion. You can get very specific about your intentions. Maybe your spouse can live in your home for as long as they want, but the house eventually goes to your kids. Maybe they receive enough income to maintain their lifestyle, but can only access principal for health emergencies. But you must be precise. When you say children, do you mean biological, adopted, or step? Courts follow definitions, not intentions. Also, review any premarital agreements. These often contain specific requirements about asset distribution that your trust needs to honor. Conflicts between those and your estate plan are a recipe for lawsuits. The key is being specific about your intentions. Take care of my spouse isn't enough. If this made you think we might have gaps, don't wait to address them. We can help you think through different scenarios, weigh the trade-offs, and make sure your plan reflects both financial priorities and family dynamics. Then we can coordinate with your attorney to make sure it's implemented correctly. Use the link below to schedule a time to walk through your specific situation. No pitch, just clarity. And this is where even the most detailed trust can fall apart. The assets themselves. Because if you don't properly connect the paperwork to the money, none of it works the way you planned. Let me show you what I mean. An unfunded trust is like writing a heartfelt letter and leaving it in a drawer, unsealed. When your family needs it most, they will find the envelope empty. The house deed still in your name. The investment accounts never moved. The result? Probate, delays, heartache. This is one of the biggest gaps we see. Documents are signed, but the asset transfers never happen. That's where we come in and work with your legal team to make sure the right assets are aligned properly over time. And it's not a one-and-done task. New accounts or investments must also be titled correctly. Some assets, though, should never go into a living trust, like qualified retirement accounts. You keep those in your name, but list your trust as the beneficiary on the forms. Now, once you got the documents, the trust, and the funding handled, there are a few situations that can still trip up even the best plans, especially in blended families. These next ones comes up more often than you think. Number one, digital wealth crisis. In today's world, much of our wealth and communication lives online, but passwords aren't enough. Federal law requires formal authorization to access digital assets like online banking, crypto wallets, and cloud storage. Suppose you have a stroke and your spouse tries to pay bills online, but they are locked out. Without the right authorization, your family could be left in the dark at the worst time possible. The fix is simple. Create a digital asset authorization and use a password manager with emergency access. Number two, family business complications. If you own a business, legacy planning adds another layer of complexity. One heir may want to sell the business, another wants to run the company. Your spouse needs income but wants nothing to do with the business. Without a clear plan, you are setting up family conflict and poor business decisions. Most attorneys recommend specifying whether the trustee may retain or must sell business interests immediately. You can also outline how the value should be divided among heirs. You can even consider solutions like using a buy-sell agreement funded with insurance to create clear exit strategies and avoid future disputes. If this is something you are thinking about, we can help you weigh the pros and cons of gifting a minority interest in the business to charity before a sale. It's a strategy that can reduce taxes, support a cause you care about, and when done right, we coordinate with your attorney to make sure everything is implemented correctly. Number three, charitable legacy strategy. If you're over 70 and a half and thinking about leaving a legacy to both your family and a cause you care about, there are some tax-smart ways to do it. Qualified charitable distributions from your IRA can satisfy your required minimum distributions without adding to your taxable income. In 2025, you can also use up to $108,000 for a charitable remainder trust or gift annuity. ensuring gifts continue without needing future approval from a spouse or children. Make sure your documents allow for this kind of charitable intent. No documents can replace a real family conversation. The biggest mistake isn't picking the wrong document or forgetting a tax strategy. It's assuming your intentions are obvious. They aren't. Not to the courts, not to your family. Some families schedule a legacy dinner to explain their decisions while everyone's at the table. That one meeting can prevent a court battle years later. Sit down with your family, all of them, and explain your plans. Yes, it's uncomfortable. Yes, people might have feelings about your decisions. But it's much better to address those feelings while you're alive and can explain your reasoning. Be especially clear about why you chose who handles what, why your son is the financial agent, why your spouse makes healthcare decisions, and why your trust might be structured differently for each heir. Talk about it. You are not just distributing money, you are preserving relationships. A well-structured legacy plan protects wealth, but more importantly, it protects relationships. And in a blended families, that makes all the difference. Every step we've covered, from legal documents to trust funding to family communication, serves one goal: protecting the people you care about in a way that reflects your true values. Legacy planning isn't just about documents. It's about creating clarity, avoiding conflict, and making sure your legacy lasts in both dollars and harmony. But here's the final piece most people never think about it. How should your assets be divided if someone you named passes before you? Should their children inherit? Should it go to someone else? That decision, per stirpes versus per capita, can either bring your family closer or start a feud that outlives you. In this video, I break it all down. It's one of the most overlooked parts of legacy planning and one you don't want to get wrong.